All right, leading our bulletin this hour, the uMkhonto weSizwe party has filed urgent papers at the Constitutional Court to interdict Friday's first sitting of the National Assembly.
Now, this comes after the party's letter of demand to the Secretary of Parliament and Chief Justice Raymond Zondo, asking them not to convene the first sitting, did not yield results.
The party seeks a hearing in the Apex Court before Friday.
At the same time, Parliament is forging ahead, planning to swear in members of the National Assembly, elect a Speaker as well as the President.
Now, the Constitution states that the first sitting of the National Assembly must take place at a time and date determined by the Chief Justice within 14 days of the election being declared.
At the same time, expelled founder of the MK party, Jabulani Khumalo, has turned to the Western Cape High Court, urgently seeking his reinstatement as the party's #1 candidate. Khumalo also wants the court to prohibit the MK party, its leader, Jacob Zuma, or anyone working under its instruction from removing his name as a member of the National Assembly. Now, Khumalo hopes for an interdictory before the first sitting of the National Assembly on Friday. It depends on Part B of his application, which challenges his expulsion and a looming electoral court judgment on the leadership battle in the party. Now, Khumalo recently challenged the IEC's record of Zuma as the party's leader in the specialist court, and judgment in that matter was reserved. Let's stay with this particular matter now and unpack it for you, just to give you a sense of what is at play here, especially with developments around the MK party. SABC News reporter Canny Maphanga and legal analyst Donda attorneys MD Melusi Xulu will be in conversation with us. But I'm going to start with Canny here in studio. Canny, thank you so much for your time. I mean, let's just start first with Section 46 of the Constitution. This is what the MK party is basing its application on as they're trying now to interdict the first sitting of the National Assembly. Let's give the viewers a sense of what this section says.
Absolutely. Thank you, Bongiwe, and good afternoon to the viewers at home. Well, of course, we've seen today, following the letter of demand that was sent over the weekend, in which they asked the two officers, that is the Office of the Chief Justice and the Secretary of Parliament, to refrain from convening that first sitting of the National Assembly. Now, we've seen that the Chief Justice, as required by law, has set a date and time, which is Friday the 14th of June at 10 a.m. After this letter of demand didn't yield the desired results for the MK party, we've seen now that they've turned to the Constitutional Court to get an interdict just, 2 or 3 days prior to this first sitting supposed to take place. And they're asking the court to interdict that sitting from convening, citing Section 46. Now, if we look at Section 46, I'm not sure if our colleagues have that graphic available for us, but it speaks of the composition of the National Assembly and really speaks to the electoral system, which is important why you don't read legislation in isolation. Now, it clearly states that the National Assembly consists of no fewer than 350 and no more than 400 women and men elected as members in terms of an electoral system. So it's quite clear what it's speaking about. When we speak of what's going to take place on Friday, which the Chief Justice has confirmed, we are dealing with the issue which will see the swearing in of members, as well as the election of a Speaker and the election of a President, as confirmed by the Chief Justice. For that, you will have to turn to the issue of quorum, which then you turn to Section 53. And it clearly states that for those decisions to be taken, you need at least 1/3 of the members to be present. That would translate to 133 out of those 400 to be present rather on Friday when they sit. So it appears that what the business of the day is supposed to be on Friday the 14th of June can proceed on Friday should they meet that 1/3 requirement or the quorum for the national sitting.
It's quite an important one, but one then asks the question, Canny, can the Constitutional Court hear this in 3 days?
Well, that's quite difficult to answer. I mean, they filed urgent papers, and we've seen how overwhelmed these courts are and the number of applications that are coming into the various superior courts in the country and how litigious as a nation we've become. And I just don't see a situation where in 3 days they'll be able to entertain this application. However, we will see. It's up to the Constitutional Court if they are able to entertain this matter and how they conclude regarding this application that has been filed.
At the same time, there is that matter of the expelled MK Party founder, Jabulani Khumalo, turning to the Western Cape High Court.
Absolutely, yes.
What is he pleading?
Well, Jabulani Khumalo is the expelled founder of the MK Party that has fallen out politically with some of those members of the MK Party. You may remember, rather, that we were in the electoral court just a few weeks ago where he was asking to be reinstated. Now, the elections were declared on the 2nd of June. You know, there was that 48-hour window period to amend those lists. It seems that he's trying to secure his reinstatement through the Western Cape High Court as well, asking for that declaratory order and that protection pending the finalization of his Part B of his application, as well as the looming electoral court judgment that we expect on this issue, because it has already been argued in the specialist court where he seeks his reinstatement rather, and he's challenging the IEC's recordal of former President Jacob Zuma as the leader of the MK Party. Now, it remains to be seen on Friday if he can or cannot attend that sitting as the #1 candidate. We've already seen the MK Party communicating through that letter of demand that they are not going to be showing up for that sitting. We've seen Parliament confirm that they've made the necessary logistical arrangements to ensure that there's no fruitless expenditure on this issue following the communication that they've received from the MK Party. So there's a lot going on in this newly formed party. A lot of court papers being filed to challenge these various issues, but it seems that the first sitting is going to be going ahead, and it is going to be going ahead in terms of legislation. Remember, when you file an urgent application, you have to show urgency, and one could argue that by the 2nd of June at least, you would have known that legislation is quite clear on the 14 days given in order for that first sitting to take place and for the Chief Justice to preside over the election of the Speaker, the President, and of course the swearing in of those members.
It's going to be interesting to see what happens then in the next 72 hours, Canny. But thank you so much for giving us that update there. That's my colleague, Canny Maphanga. Of course, just before, we even wrap up this particular matter, we'll now be in conversation with Donda Attorney's MD, that's Melusi Xulu there. Melusi, thank you so much for your time. Let's just start with the fact that right now, from what we're hearing and what we see as Canny is explaining the different sections, one would say that it does look like it's self-explanatory. So what are the prospects of success when you look at the MK Party's interdict?
Okay. Good afternoon to you, Bongyo, and to the viewers at home. Thank you for having me once again. Before I go to the prospects of success, I think it's important to at least look at the angle of the MK or the legal representative, what they are trying to say.
Yeah.
Or in particular to section 46, subsection 1. It basically says, as you say, the National Assembly must consist of members no fewer than 350 to a maximum of 400. That's how the composition of the National Assembly must be. Mm-hmm. So the question is, if there are fewer members than 350 or less members in relation to the numbers of which is 350, does that constitute a National Assembly? I think that's the question that might be clear, because obviously when it comes to interpretation of the law or constitution, we'll always have different views, but ultimately the constitution will assist. So I think
so before you move on, pardon me, Melusi, let's stay with that so that we don't lose it. Before you then move on, so I suppose it will be important for the Constitutional Court then to provide some clarity on this matter, especially because, as you say, one person can say, but it talks about the composition of the National Assembly to say that at least let there be no less than 350 of the members and not more than 400. Another one would say, but no, it also speaks about the composition, especially after the elections, to look at how things must be. So it's important then for the nation to understand what clarity then will be provided by the court.
Thank you. That's correct. Because I think there is another school of thought, of course, that says, let's look at section 53, subsection 1, paragraph B. But if you read it at the beginning, it says, except where the Constitution provides, when it comes to decisions of the Constitution, there must be 1/3 of the people who must decide or must vote on an issue or a decision that must be made before an assembly. But that particular assembly, how much or how many people must be there for the National Assembly to be formed? So I think that differentiation, or how Section 53 works with Section 46, specifically those subsections that I mentioned, that is where the Constitutional Court must give us a light, because there are some that are saying, no. For this particular decision on Friday, only 133 or 134 members must vote, and the ANC has 159. So once there's that 1/3, the National Assembly can proceed. But how do we then interpret that number that is 350? I think that is where we must start, and then it should be clear that the Constitution will interpret for us. But I think the Constitution has to clear up what does it mean if it says no fewer than 350.
It's interesting, that all of these are coming up right now, and I suppose for finality's sake and for clarity when it comes to the future, it is important that these matters find themselves in that court. But Melusi, one then asks the question, what happens then if, for example, they're not able to elect a speaker or a president on Friday, and this doesn't go ahead? What does it mean for the country?
I think what it means for the country is what the MK has been trying to sort out, that there must be a revoting that must happen, So I think that is what might be looked at, but it will depend if the MK succeeds on what they want. First of all, then we'll look at what the next option is. But I just want to highlight the reasoning of the MK. Maybe that needs to be looked at, and whoever opposes it might have to answer to that. The MK has specifically stated, not only the MK, but many other political parties, they've raised 579 objections. And they feel that the IEC did not take enough time to look at those objections, specifically when they, inverted commas, they rushed to declare the elections free and fair, From 50 objections in 2019 to 579, I think they are saying it's quite a lot of objections, and the IEC should have not rushed to respond to the markets, inverted commas. So those are the things that they are raising. And the other one that I feel has not been, given much attention, on the 31st of May, on Friday, the IEC, I'm not a technical person, so that's why I have a question. The IEC data center was not working for 2 hours. So there was no question, there was no answers to the questions, what happened and what was the effect of that, because we are living in a technological age. If something like that happens, there are questions as to the veracity of how the elections were, the election was done. So that's what the MK is trying to raise, to say maybe the IEC should have given itself enough time to look at the queries that are raised. But in any case,
Pardon me for coming in there. I don't want us to run out of time before we touch on this one, because it will also be interesting to then hear what the IEC has to say about what the MK party in its papers is also talking about when it comes to, as you say, some of the technical feeder issues, some of the issues of deletion of data, as they're claiming that they do have this particular report. But before I let you go, there's something else that I want us to talk about, Melusi. It's the issue of Jabulani Khumalo. He's now approaching the Western Cape High Court, and he's seeking that kind of protection so that he stays on as a member of parliament. Let's talk about that particular case and what you are reading into it.
Okay. What I'm reading into it is that, first of all, the MK have stated that they no longer need him to be part of their political party. So they've stated that he's no longer there, and possibly they will replace him. So I think what I find interesting is that, from a political standpoint, if he would call the MK to listen to what he wants, or the members, they will not listen to him, from where I'm standing. So I think maybe legally he does have some, something to stand on, but when it comes to the numbers that are supporting him, he might have a challenge, and those numbers might determine whether he still stays or doesn't stay, if he continues to push, to be part of the National Assembly or whatever he's trying to do. So I think, yes, maybe legally he might have something to stand on, but ultimately, what if the party recalls him, because he doesn't have the numbers? Because let us be honest, from a political standpoint, if he was the president, who would have voted for Jabulani Khumalo? He doesn't have that numbers. So he's speaking as if he's a person who has numbers, but I think that's what might be a challenge ultimately. Yes, maybe legally he might have some technical points, but if he doesn't have the numbers, the people do not know him. So why is he trying to push? But anyways, it's his right to challenge. But let's see how the members or the constitution of the MKP will say about him continuing. Maybe they will have something to say about it. But I'm just having a curious, understanding of the fact that he doesn't have people supporting him.
All right, so Melusi, I hope we speak again then when we see how the Constitutional Court then proceeds on this matter. So a very crucial 72 hours. And as you say, the developments around Jabulani Khumalo. It'll be interesting then to see how all of this unfolds. That was legal analyst and Donda attorneys MD Melusi Xulu. When we take a short break, when we come back, we have more for you, especially when you look at the composition of our government, the 7th administration. Everything still undecided up in the air. So we will then be talking to some voices there.